Good morning. This is Senate Judiciary. This is Wednesday, March 13th, 2024. We are dealing with acts relating to bail and violations of conditions of release. We have with us Benjamin Novodowski, the Legislative Counsel, to walk us through a markup and consideration of S-196, which is an act related to types of evidence permitted in weight of evidence hearings. And then following that, we'll have continued discussion of S-195, and that's an act relating to how a defendant's criminal record is considered in imposing conditions of release. So the committee's objective here is to improve the system in terms of violations and conditions of release and to improve public safety. We've all heard from constituents concerned about people who continually violate conditions of release. Basically the subject here. So Ben.
Good morning. For the record, my name is Ben Novodowski from the Office of Legislative Counsel. As you said, Senator Sears, before the committee is S-196. I need to correct my testimony from the last hearing just to clarify really what the bill is trying to achieve and what the current state of the law is. What I was discussing last time was really relevant to the evidence of this great standard within this analysis. So as a refresher, and I encourage the committee just to keep this handout from the beginning of the session handy for persons without bail. Now, under 13 VSA 7553A, which is typically, when there's a hearing, typically known as a weight of the evidence hearing, the state must prove evidence supporting the felony charge demonstrates that the likelihood of guilt is great. If the state makes that showing, the hearing proceeds to the next stage where the state must prove that the defendant's release poses a threat of physical violence and no combination of conditions will reasonably prevent such violence. It's that second step that this bill is trying to address. Because currently, under the current law, for the first showing, the Supreme Court has held that a weight of the evidence hearing that prosecution must establish that substantial admissible evidence of guilt exists and that the evidence can fairly and reasonably convince a fact finder beyond a reasonable doubt that the defendant is guilty. That was really the bulk of what I was explaining very inartfully and in sometimes incorrectly at the last hearing. And this has been established that it can be shown through affidavits, depositions, sworn oral testimony, or other admissible evidence. So once the state meets that showing, the Supreme Court has opined on the kinds of evidence establishing that the defendant's release would pose a threat of physical violence and no conditions will reasonably prevent it, but has not opined on the forms of evidence that is required to make that showing. So what this bill does here is, by adding subsection B to the statute, this would align it with the bail hearings under 7554 and also the life imprisonment hold without bail hearing under 7553. And the reason why that exists is because in both of those statutes, there's either in 7554, subsection B, the language that's in subsection B here already exists in 554, with the exception of the last line, which would maintain that guilt is great standard, which is the first step of the analysis. In the hold without bail for life imprisonment, there's a reference to 7554 for the second stage of that analysis, which is different than here, but the point is that the evidentiary standard or the admissibility standard is already worked out in that statute. So what this does is, by adding subsection B here, is that it puts a 7553A hearing on par with 7553 and 7554. And so it's to basically make them all treated equally as far as the admissibility of evidence. And for this one on the second stage.
Either you or Senator Sheen give me a real life example of how this would work?
Well, I can probably give a case example. So for instance, this would be a better question for Dan and Evans. I know that.
I can
Yeah.
provide somewhat of an example. I think that, for 7553A hearings, you're talking about serious violent felonies or aggravated domestic assault, shootings, stabbings. With 7553, you're talking about life imprisonment, which generally homicide, right? So what would happen with the hearing? So you have this hearing within 15 days of arraignment, and it's to determine whether or not a person can be held without bail. And it's a pre-trial hearing, so and so you also have a similar hearing that happens for 7553 situations, which are generally homicides or life imprisonment cases. And so what happens in some courts for the 7553A, which are the serious violent felonies, is within those 15 days, it's being interpreted that the evidence has to be lawfully admitted into the court rather than showing that it can be admissible later on. And so this ends up, within that 15-day window, you can see in some courts victims being required to testify, even though a week or two prior they were shot or stabbed or assaulted in an aggravated domestic. And so that's the problem that's trying to be solved. They'll still have to testify in the trial.
This would avoid them going through the trauma.
Right.
Yeah, of having to relive it within a few days, essentially.
Or a few days at a time.
And especially with the fact, when you consider that you don't have to do that for 7553, which are more serious crimes, it doesn't quite make sense with the way some courts, in my opinion, are interpreting it.
Yeah. Thank you, that's all.
Good
Sure.
Thank you.
Yeah, thank you.
So that's essentially what the bill is trying to achieve, to put that second prong of the 7553A analysis on par with what occurs in 7553.
That sounds good to me. I'm fine with either passing it on its own or adding it to 195 and 6%.
I'm fine with
It's his bill, I think maybe it deserves that special as a separate bill.
Oh, well, thank you. Yeah, I'm fine with voting on it.
Because you could report this on the floor and not get it involved in all the bail stuff.
That works for me. I'm fine with that.
That's okay with the rest of you.
That'll be fine. You don't want to report this one?
Sure, Bill.
I'll leave it to you. It was confusing. Perhaps you can confuse the whole Senate.
No, but I think,
You did a great job right now.
Yeah,
so,
yeah, he just explained it, so I don't think there's a problem.
I just feel like
He
we've
just
gone
gave
back
his
and
report.
forth.
Yeah,
That's
very
it.
brief.
Yeah, I'm fine with it
You
being.
may want to pump it up a little bit.
Oh, yeah, I can add some.
Gory details.
Yeah.
Get a really good case example.
You
Yeah.
can borrow my pink shoes if they help.
Oh, thank you. It might. I tried to find a suit that they
Mm.
Well, so it would go out as, just as introduced.
Yeah.
No changes.
Wow.
That never happens here. Sure there isn't a word to change.
Should I be look for one?
A shall or may or something in there, they don't.
Yeah, I know, strike them all. They're always strike. Now,
It just came out that good. What can I say? I'm just kidding. Just kidding.
you got quite a crew on there.
Oh, yeah. Oh.
You got Kitchell and McDonald. Churchill, Hughes, and here. It's bipartisan. All right. So Senator Sheen moves that we report favorably S 196 as is.
That's running a check, you can see the Senator Booth.
Yeah.
Thank you.
Senator Broder, if he's available.
Senator Machine has moved that we report S-196 favorably with no amendments. S-196 is a bill that seeks to make compatible evidence, what's allowed in evidence for both serious bodily injury crimes as basically murder. Is there any further committee discussion or any discussion in the audience?
No, Mr. Chairman.
Hearing none, Ben, would you please call the roll?
Senator Booth,
Yes.
Senator Norris,
Yes.
Senator Walowski,
Yes.
Senator Sheen,
Yes.
and Senator Sears.
Yes, it's unanimous, so Senator Steen has volunteered to report the bill. Did actually a very good job of reporting the bill during the committee discussion. So he was elected.
Happy to do so.
And Ben?
And thank you, Ben, for the presentation.
Well, that moves us up by 30 minutes on our agenda. I think we could use a lot of discussion of S-195, so that's helpful to have some extra time.
2.2s.
Draft 2.2 of the bail bill. And I gotta stop referring to it as bail. Just, it's really violations of conditions of release.
So before the committee is draft 2.2 of a strike all amendment to S-195. The majority of the changes have been highlighted for convenience and ease of reference. But just at the outset, what was formerly section 12 has been struck. That was the creation of the misdemeanor docket. So that is no longer within the bill, and then I'll highlight some other changes as we go
Well,
through.
could you hold that for the miscellaneous judiciary bill?
Sure.
I think it's still worth the discussion. And if we're going to increase the budgets of the judiciary, the attorneys and the defender general, or recommend, then I think, you know, I've heard enough testimony from the attorney general and others that the misdemeanor docket would lead to some of these minor misdemeanors being dealt with because people know they're going to trial and then they make a plea. And we gotta get rid of it. I mean, that's part of, and I can't imagine if I was charged with a crime and waiting 3 years to have my crime, you know, or if I'm a victim and I'm waiting 3 years for a minor misdemeanor. Just not fair to the public. So I'd like to reopen it in and so if you could coordinate that with Eric.
Sure.
Patrick. I realize the judiciary didn't like the idea.
So I will happily coordinate with Eric on the miscellaneous bill on that misdemeanor docket. So moving forward on this new draft on page 2, you'll see highlighted just some adjustments based on the testimony, last time, that it now reads that the $200 limit shall not apply to an offense allegedly committed, not committed. That way, it stays, because the person is yet to be adjudicated, by a defendant who has been released on personal recognizance or conditions of release pending trial for another offense, just to clarify the status of the defendant at that time. Then moving on to page 4, you'll see that added to the list of conditions that can be imposed at arraignment or at a bail hearing, the GPS or electronic monitoring program has been added as subdivision H at the bottom of page 4, and then at the top of page 5, the home detention program has been listed as a condition as well. So those are, and you'll see that those can be levied.
How do we make clear that both of these programs are only eligible to people who would otherwise be incarcerated?
Well, if that's the direction of.
Well, that's, I think, the direction. I don't want to see this overused. By the same token, I want to see it used.
Right.
People who would be otherwise, particularly where the victim and the example of the Windham County Sheriff's Office program, it was full of good reports. It was well recognized, but it took people who would otherwise be incarcerated and put them in. I don't want people who would be out on their own recognizance ending up in a home detention program.
Mm-hmm. Well, so the analysis for how these are all imposed is that it's the least restrictive condition or combination of conditions. So that in and of itself is a sort of check on that these are arguably probably the most restrictive conditions that would be listed outside of one that the court just comes up
Well,
with.
could we say something like somewhere that the home detention program is designed to be the most restrictive, non-incarcerated program?
We could probably, we could work that in either into the home detention statute or into 7554.
Into the policies they develop, who's eligible would be something of that nature.
Yeah, well, and one suggestion that Judge Zone and I discussed that I know I believe he's brought up to this committee, or it was just as oversight this summer, is to completely revamp 7554 itself so that it reads a little bit easier. It's more compact, that there's just one set of factors, not sort of this 2-stage analysis because in reality, most judges just do the analysis sort of all at once. So it was a suggestion for the committee to consider sort of a streamlining of the statute to make it a little bit cleaner, and that would provide an opportunity to perhaps write in the language that you're suggesting now, if that's the direction the committee wanted to go.
Well, I think the committee was in favor of making it limited to those who would otherwise be incarcerated. I mean, there's no way to prove you would be otherwise incarcerated, but if you make it the most restrictive, non-incarcerated alternative, then it would have to be used for. Right.
But it would still be the least restrictive that would accomplish.
Right.
Yeah.
That makes sense to me, and I think it helps address some of the concerns we've heard about it being sort of overused in a biased manner.
Mm-hmm. Jay's testimony. Yeah.
I certainly support, even if the analysis would already be that it is the most restrictive, sort of really naming that this is the most restrictive and should only be used if the only other alternative is detention.
Yeah, and if you look on, farther down on page 5 at the bottom, you'll see subdivision D, that impose any other condition found reasonably necessary to protect the public except a physically restrictive condition may only be imposed in extraordinary circumstances. Language like that could maybe be appended to the home detention program, basically saying it should only be used in extraordinary circumstances or something.
Well, I don't want to use extraordinary because it's underutilized right now.
Right.
That's part of the problem, and it's passive, which doesn't give much confidence to victims or to law enforcement or state's attorneys, so they're not using it. And it needs to go back to an integrated system, in my view.
So I guess my clarifying question would be, it's clear that this is, there should be some statement saying that this is sort of the most restrictive condition.
Non-incarcerated.
Non-incarcerated. Do you also want it to state something along the lines of that it would be limited to those who would otherwise be incarcerated?
I don't think we should do that because, the variance from the count, I don't know how state's attorneys feel about it, but I would think you have a variance of what different courts do around the state. So as long as we make it clear it's the most restrictive, I think that the defense can argue that there are less restrictive matters that can.
But are we, I know it's obsessing about the phrase, but least restrictive is in all the case law. If we call this most restrictive, even most restrictive other than incarceration, are we setting up a problem where where their attorneys would defend them against a part of the statute that now refers to it as the most restrictive? You see what I'm saying?
I think so. I mean, it's potentially, so the least restrictive language is in the statute too.
But that's what I mean, like,
yeah.
can we, instead of saying it's the most restrictive other than incarceration, can we say that it's the least restrictive, when the only other option is incarceration or something like that?
Right.
Because I'm just worried if we start using the phrase most restrictive.
Yeah.
Mhm.
Well, I'm sorry.
Senator Bahowski, and then if we could hear from.
Yeah, so I just want to get some clarity. We're talking specifically about home detention. How does that differ from the electronic monitoring? Because what I heard from Jay was that there was concern about both of those, particularly the monitoring being expanded to the point where people were being surveilled. So I want to make sure we're addressing kind of both of those concerns. And my understanding from the language in this bill is those are two different programs, home detention and electronic monitoring.
They are. I think the simplest way to think about it is home detention is essentially your prison, your home is essentially your prison cell, with the exception of permitted appointments, court dates, medical appointments, things like that. Work, exactly.
Whereas electronic monitoring, you can go live your life.
Potentially, it depends on what the conditions of the monitoring would be, but yes, it's more, you're not necessarily restricted to a physical location.
My understanding is with electronic monitoring, they can even monitor whether you're drinking or not.
Right, if they have the alcohol sensor on the bracelet too.
You stop for a glass
yeah,
of
so
wine.
it would monitor you. Typically it would be if it might be used if you can't go to a certain location. Or
I think it's used more to keep people away from the victim.
right, exactly. So it's not as restrictive, at least on its surface, as home detention is.
Yeah. When I think what we heard from Jay, and I'm hoping we have the Bureau report that they referenced, is that when someone is placed on electronic monitoring, they are more likely to be, picked up for having a glass of wine, not actually doing harm. And if that's overused, it may be overused in sort of a biased way. So I just want to make sure that we're sort of putting I want to see it used more, so less people are detained. But I want to put some guardrails so that it's not expanded, so that everyone on conditions is now being electronically monitored.
Well, and again, going back to sort of the least restrictive means analysis, all of this. I think that you could put in some language sort of classifying them, so to speak. But on its face, when you really look at sort of how the different conditions go, they almost are sort of escalating as you go down them. And so the court, on its face, I think would understand the more restrictive natures of these on their own. And there's also the factor about resources and the ability to monitor these people, which may serve as a natural check, but not as explicit as I think maybe you're saying. But I think that's important just to realize in the context of it all.
Tim, did you have some comments?
Yeah, so the least restrictive piece, Tim Leaders-Dumont, Department of State's Attorneys, as Ben has pointed out in his presentation from, I think it was January, but if you look back at that, the first part, A1 of 7554, is about both whether or not to impose bail, and if you aren't imposing bail, always with the presumption of recognizance being the presumption that you ROR, recognizance. If that doesn't apply, should bail apply? If that doesn't apply, now you're talking about conditions. Always the least restrictive. What set of conditions? And they list in the statute what those conditions might be. Electronic monitoring is in the menu, as Ben suggested. If those conditions are not deemed to be something that could protect the public, then you move on to the second part. That sort of more, a little bit more concerned about public safety. Now you're in part two. Again, electronic monitoring is in there and least restrictive is in there. So if you think about least restrictive, the judge, who is the imposer of the conditions, not the prosecutor, not defense, we sometimes say, here's what we suggest, but the judge is always exercising discretion. It will be the judge who does that analysis, sometimes based on our arguments of, you know what, in this situation, we have 2 victims in the community, violent case. I'm going to give you an opportunity to be in the community right now, imposing electronic monitoring. And it sounds like that's the least restrictive of all the menu options today. And so it's a very, as you said, fluid analysis. But right now, the current 7554 has that least restrictive piece in play.
Where does the victim come in on the electronic monitoring or home detention? Do they generally get a voice?
So with electronic monitoring, we would certainly, as we do with all bail arguments, bail-related arguments, conditions arguments, put in the whole swath of information. Like the victim does not want to have contact, right? That would be a big one. The victim's in favor of community release with electronic monitoring. We try to incorporate all of that into our perspective, and a good judge will also ask, what is the victim's perspective in this situation? Home detention, as it currently is in law, is they are going to be detained because of lack of ability to pay bail. And so there's that extra analysis that happens, which is why it's so narrow right now. Why, as you said, there's not many people that are on home detention. So if you're broadening the home detention program, the issue is if someone violates home detention, where do they end up? I don't know if that's addressed in the current.
Well, and the way that the home detention program is structured, or the GPS monitoring program is structured in the bill. So if you turn to page 16, and this is the GPS monitoring.
Go ahead. Question after Ben.
Okay.
Is part of the analysis that the court does. So this is bottom 16 on the 17. You'll see going on to 17 that the court must consider the nature of the offense, defendant's prior convictions, history of violence, medical, mental health needs, history of supervision, risk of flight, history of compliance with court orders, and any risk or undue burden to other persons who reside at the proposed residence, risk to third parties, or risk to public safety that may result from the placement into the program. So that is the factor about sort of, that would include victims.
Yeah.
Okay. So my question is maybe for Tim or maybe for Ben. The current home detention program is it's not about public safety. It's about holding people who are poor in their homes.
No, so the current home detention program is they already have, you think about it almost like a multi-stage process. They have bail imposed on them by a judge, so they haven't been able to pay. If that has been satisfied as let's call it a requirement, but something that's in place, then the judge or corrections or the defense can ask, how about home detention? Maybe that's a better alternative to detention in an incarcerated facility. And then that analysis that Ben just described comes into play. So the current home detention program is only for individuals who have bail imposed on them right now.
That are too poor to pay. So we are using the most restrictive thing simply to hold people in their homes because they're poor.
So, I mean, the analysis as to whether or not someone has bail imposed on them is based on the judge's individual analysis there. So I can't speak to the subjective comment that you made about their inability to, their status economically, but it would be all the individuals on home detention last time I checked were of very serious crimes. So aggravated assault, attempted murder, that sort of thing. There wasn't anyone in there for, possession charge, that sort of, just so you're aware of the current population that's on home detention.
Because, and,
Well, I wanna make, I wanna talk a little bit about the last statement from Senator Blahowski. Is that a fact? Is it, are people on home detention because they're poor, or because the bail is sufficiently high that they can't meet it? Which I thought we were supposed to set bail at. Well,
so I can,
I'm a little confused.
I
now
can
by
kind of
the-
answer both
by-
questions. I mean,
Yeah.
one, so, I mean, people would, the way the statute reads is that if they're incarcerated for 7 days or more and haven't, for reasons and not making bail, they're eligible for home detention. So the alternative is they're not in home detention, they're in prison. That's why. But then as the
But if-
second,
if-
the
Using
second,
a real life example, if you're Donald Trump and you get an $84 million judgment, you put up $100 million, you can get out of jail.
right,
If I don't have $100 million and I don't know where I'd find it, so I'm in jail if I did the same things he did.
so,
And that's one.
yeah, I mean, I
think.
think,
I don't think I'm poor, but I don't have.
I think you could characterize it that way, that if if you don't have the money to meet bail,
But if the bail is set at 25,000,
Mhm.
let's say, 100,000 is easier because I can do the math. The bail bonds person would put up 10,000. If somebody, is willing to mortgage their house or whatever, their collateral for 10 grand, right? That's how that system works. We're not talking about $200 bail here, we're talking about large bail.
right,
So if I can come up with that 10,000 and I can get out. But if I'm really poor, I don't have a shot at that, then that becomes what Senator Bowski was just talking.
well, and then on the part about.
But could I end up on home detention even though I have the 10,000?
Well, if you can make bail, however you do it, either through bail bonds or whatever.
It's only to mitigate flight risk, right? It can't be public safety, the bail.
Correct, that's,
Yeah.
yeah, and the way sort of the financial means analysis plays into all of this is that, yes, a person's financial means is a consideration in the bail analysis. However, the way the case law is that bail cannot be excessive, but it also doesn't have to be affordable. Is basically, and it kind of seems like a misnomer or contradiction of words, but basically it can be set at a point high enough that they think that the court feels will keep the person in the jurisdiction and keep them coming to court appearances. And if that is, but it can't be excessive, and what excessive is, I think, a subjective analysis based on the circumstances, but it doesn't have to be affordable either. And I know that seems like a contradiction of terms, but they're, and the person's ability to pay or financial means are considered in the bail analysis, but that's sort of the upper level restriction.
Going back to our original goal here is to reduce the violations of conditions imposed.
But just,
So that's the goal of the bill.
yeah, no, it just for me highlights my sort of fundamental issue in your example. So because someone has more money, they can pay bail and go around and do whatever they want. But because someone has less money, now their options are jail or home detention. It is inequitable and punishes people for not having money. And so it's a problem for me that that's how it is currently in statute.
Well, I
But-
can talk about how the bill changes
Okay.
that.
Right?
So,
How the bill changes that.
okay.
Maybe
Well,
one-
Wait, does it change it for the better?
Probably not.
I'll leave that up to the policymakers.
No, you never know.
All right.
You're right.
But just picking up where we left off quickly, so
Yeah.
those two conditions were added to both analyses of the bail bill. The one talking about risk of flight, and then the second set of factors to address public safety. And that's on, you'll see that second set on page 6 as well. Then on page 7, there was just a small change in the highlighted language here. There was some confusion about standing orders related to public protection. I changed it to just whether the accused is currently compliant with any court orders to quell that confusion. And then at the top of page 8, changing a will to may.
Just before we leave page 7.
Yes.
So we're adding a number of considerations to the list for the judicial officer. And then the final one is whether they're currently compliant. Or not the final one, but the final one we're adding.
Well, yeah, so these were all there, and this final one here was just, it was present, I just changed it a little bit. And Judge Zone has testified that most judges already kind of consider these factors. So it wouldn't necessarily be a burden to explicitly list them to make sure there's consistency throughout the courts.
Yeah, that's good.
And then that small change from will to may, and then going on to page 10 is the beginning of the home detention program. So right now, the definition of what home detention is hasn't changed. What does change though is who is eligible. So you'll see at the top of page 11 in subsection B, it now reads that at the request of the court, the Department of Corrections, the prosecutor, or the defendant, the status of a defendant who is detained pretrial in a correctional facility for inability to pay bail after bail has been set by the court, this is the current eligibility requirement, or the status of a defendant who has allegedly violated conditions of release or of personal recognizance may be reviewed by the court to determine whether the defendant is appropriate for home detention. So that's the new eligibility expansion, is that it's someone who has been accused of violating conditions of release or personal recognizance. That's the expansion.
So when they went through on their original charge, they were not eligible. And so they got conditions of release, they went out, they violated them, but now they're eligible for the home detention program. And it's up to the judge to do the analysis, whether that's the least restrictive means of achieving the goal.
Correct.
Okay.
So that helps with Senator Bowski's concern.
Well, no, it's still,
Well, we can't
still,
get you all the way there, but maybe 3/4 of the way is better than.
I mean, I appreciate that it is, that home detention is better than being incarcerated. It doesn't change my fundamental issue it doesn't change my fundamental issue with bail. That's the problem. The problem isn't the home detention program, it's that I think bail is an inequitable issue.
At root, it's money in the system,
Right.
right? And it's, your argument, I think, is that it's corrupting, just by being there, that we're charging money to some people and based on ability to pay, you have different outcomes.
Right, I think yes, and I think that, what we've heard in testimony on this bill and other bills is 95% of the people charged with crimes in Vermont live in poverty. And so we've already criminalized poverty, and now we're saying that those people who can't afford bail are going to be.
We haven't criminalized poverty.
Well, if 95% of people being charged with a crime live in poverty, I think it's a pretty good indicator that poverty.
But to say that we criminalize poverty.
Not we personally, we as a society.
I don't agree with that, but that's okay. Most people are eligible for a public defender. It's questionable how many of them actually are eligible, because I don't think the courts do a very good job of determining that level. But so I just yes, if you have money, we've seen it, Yes, if you have a DUI, for example, and you have money, you can hire a good attorney. You can't get a public defender for first offense DUI, I don't think.
I think Senator Hashim and I have a bill that would change that.
Oh, I don't think you want to change that.
I do.
I'm not sure you want.
So I think where I sit is like, if bail had to be affordable for people based on their finances, I would feel better about this, but I don't know. It, rather than like, oh, you have to consider it, but you don't actually have to make it affordable.
Well, how does going back to home detention program, the implementation of that seems, I'm now convinced that we have the language here with the little additions we talked about to make clear that it's an alternative to incarceration, not an alternative to release on your own recognizance.
I think that's fair.
Which, you know,
And, you know, back to where we started on the purpose of the bill, if the idea is to intervene meaningfully in somebody who keeps violating, I think this language is getting at that. It's giving the judge the tool to do it, so.
well, I think it's consistent also with the Justice Reinvestment II report that there needs to be alternatives.
Well, if there are no more questions on this portion of home detention, I'll move on to page 12, subsection C, which is what occurs when there's a failure to comply with the conditions of home detention. Currently, under the current statute, DOC has the ability to revoke someone's home detention status, you know, for an unauthorized absence or failure to comply with any other condition and return them to correctional facility. Given the change in the eligibility, now what would happen is that the Department of Corrections may report a defendant's unauthorized absence or failure to comply with any other condition of the program to the court for a review of conditions pursuant to section 7554, which is just the bail statute, violations of conditions proceeding pursuant to section 7554E of this title, which I'll get into, or a prosecution for contempt pursuant to section 7559 of this title, which is the current mechanism to enforce a violation of condition of release, or a bail revocation hearing pursuant to section 7575 of this title. So sort of a menu of options that if someone doesn't comply, that the court or a prosecutor can pursue.
I'm wondering if this would be this, so, and again, I just don't totally understand, is there an electronic monitoring component to home detention?
So it's active monitoring and passive monitoring. Active monitoring is like real time, and it's very staff intensive, and you know, now that the department just walked in, I'm sure that they can explain it a little bit more in depth than I can. And then passive monitoring is not real time, where, you know, for instance, people were home for the weekend and then they reviewed the person's, you know, log essentially, and they said, oh, they had these unauthorized absences or departures from their home. They'd have that record, but it may not necessarily, you know, if it endangered somebody, it's not real time, so they wouldn't be able to respond to it.
Okay, that's helpful, because I'm wondering if this is one spot where we need to make clear that it can't be revoked for a legitimate technical failure. You know, if a snowstorm knocked out my power for the weekend, I should not be headed to prison because it appears that I have gone off the monitor.
Yeah, you could write something to that effect into the statute.
I'm surprised that doesn't already exist. In existing statute, there's no recognition that there might be a glitch in the technology that's not
Not in the current statute. I mean, maybe in practice it's done that way, but it's not in statute. And you know, a potential explanation for that is, you know, these people are under the supervision of DOC. DOC sort of has sole discretion to revoke them and return them right out of the gate.
So maybe, well, it's already here, it's already permissive language that they may report. So maybe that's the.
Well, and that, yeah, and so that does give the department flexibility.
Okay.
So I guess I would be more interested in just hearing, because I'm not familiar with the electronic monitoring system. When we talk about the power going out or whatever, how does the monitoring system work? Is it on Wi-Fi and is it on somebody else's Wi-Fi rather than have to be on Wi-Fi in my house? I mean,
Well,
that's what I'm more concerned
I
about.
do know that, so if you look at the initial process to determine if someone is appropriate, right? So this is all sort of in the procedure on page 11. So basically, the review is scheduled upon the court's receipt of a report from the department determining that the proposed residence is suitable for the use of electronic monitoring. Basically, from what I understand, is that the department will say it's suitable if they have an active landline or cell service, if I'm not mistaken, as well.
Yes, I think it is also satellite driven.
Right.
Because you can do geofencing around certain residences.
So basically, they have to be able to make sure that there's a reliable landline, cell phone, or satellite.
Yeah, I don't think we've had.
That's clear to me.
I don't think we've had many issues, as the senator mentioned, with it shorting out or kind of technical issues that
So they don't have to have Wi-Fi capabilities at their residence?
I don't believe so.
We can also share the policy with you. It's on the department's website.
I certainly appreciate that there haven't been many issues, but there's, 6 people on this program. So I think if we're talking about expanding the program, we might see more issues. And I just feel better having it really clear that it can't be
Trying to get,
We
used.
do use electronic monitoring for field supervision, not just home division, but it has much wider use than that.
Field supervision meaning like
Like
furloughing?
probation, parole.
Yeah, okay.
trying to get a copy of the Lincoln County Sheriff's report, see how they, because I think in that report there was, I was trying to find it in my pile of junk and I don't have a good file. I'm not like Jane Kitchell. I don't know how she does it.
You're not like Jane in many ways.
No, but, I don't know how she does it, but I remember I think there were some issues there that addressed your concern. But again, the problem is the passive. And I don't think the courts particularly, or the state attorneys was thrilled with that.
Well, that might be addressed by, on page 12, the addition of subsection E, which is the program support that the department basically can issue grants or contracts with any entity, public or private. That
That's
meets the department's
where
requirements.
Jay had suggested removing private. I'm not sure who private is. I don't have a real concern with that.
Well, I think Jay suggested removing for profit. Because, and I agree, I don't think that people should be making a profit off of someone's incarceration. And so private could be a nonprofit, but for profit.
I would argue the state's making.
I could adjust that language to
I don't agree
say,
with that either.
any entity, public or, nonprofit, something to that effect.
Yeah.
I could-
My whole idea was that states could get together and do it. That don't, smaller states. I mean, it could be done in Wyoming, for God's sake. Doesn't need to be contiguous, as long as they have. You wouldn't believe the internet on a cruise ship. It was faster than at home. I mean, I read the Boston Globe every day while I was on the sea, and it loaded faster than at home. And so the technology is there. You can do it out in the middle of the Atlantic.
Well, that's easier than the mountains, though.
I suppose, but
Flat.
But the cell towers are far away.
yeah, but they're doing, I think it's called Starlink.
Elon Musk.
Yeah, 'cause
Lovely.
I can remember years ago, the cruise ship, the internet was like, the old dial-up where you had to wait off of your phone. So I think the technology is there.
That was Senator Sears on program support, line 13, where the department may support the operation of programs through grants of financial assistance, whatever. If in fact, are we tying DOC's hands by eliminating that section, or do they have the capability to do this on their own? It's nice to sit here and talk about it, but I mean, I'd
I
like to hear
don't
some.
think they want to.
I'd like to hear some
I don't think
testimony.
eliminating the section, just eliminating.
Nonprofit or,
For-profit.
For profit, so it would just say public or nonprofit. So it just restricts for-profit private entities from being contracted with.
You can't be in it for money.
Yeah. And
We just raised to the committee, I'm not sure how many nonprofit
Yeah.
electronic monitoring it could imperil the operation of the program.
So is it a for-profit company now that?
I would imagine the contractor.
Uh-huh.
I would imagine it's a limited space and that if we restrict it, I don't think there are any real public companies. It just might make the program of home detention using electronic monitoring not feasible.
Yeah. Although it is unsettling to me to feel as though we turn over surveillance to for-profit companies. That's
Well, are there
a scary
restrictions?
road to go down.
Well, but are there restrictions on what they can gain in terms of information about an individual?
I would imagine, we would want to see robust privacy protections, but Senator, to your point, I mean, the phone that you have in your pocket right now, which tracks your location, is also operated by a private company.
True, but
my
I think-
liberty interests aren't at stake with the
Yeah.
phone in my pocket.
people who are under detention are not protected in commensurate ways. Is it possible to, for you to tell us maybe by tomorrow who it is, what company it is?
Yeah, those contracts are public, so.
Okay.
Yeah.
Just never thought of it before.
Excuse us.
Yeah, come in. Why don't a couple of you stay while we outside?
All right,
Yeah, we can get that information.
moving right along.
I believe these are social work students from Castleton.
Oh, Castle. Closer to Bennington than most of the
Yeah.
visitors we get here. Good morning. Welcome to Senate Judiciary. We're discussing a bill dealing with violations of conditions of release from prison. Go ahead, Ben.
Okay, so are there any other questions on the home detention portion for now at least?
Not for now.
Okay.
I have one
Yes,
point,
sir.
I didn't know, you may want to hear from Judge Zone about DOC reporting a violation. Functionally, how that might work in practice, I would want the judge to weigh in on that because the provisions about lack of compliance with home detention, you have the menu, basically. There could be a contempt proceeding, there could be this new proceeding, but a DOC employee reporting something to the court, the way that functionally works right now for BOPs is they are sent to the prosecutor as well. And so a judge receiving something directly from a DOC employee, I would want DOC and the judiciary to weigh in on how that would work functionally, so that, the state's attorney would also have weighing in. So just maybe a minor, there, but I want to flag for DOC, the judiciary, and Mr. Judge.
Yeah, another consideration with that too, maybe just to say to the court and the parties, so that everybody has a copy of that report.
While we're there on home detention, we did ask for a joint fiscal analysis, right?
Yeah, it's being done right now.
It's being done, so that would be there when we get to appropriations.
So moving on to section 4, which is the addition of 13 VSA 7554E, which is the new mechanism to enforce violations of conditions of release. You'll see some changes were made based off of the testimony last time. You'll see on page 13, line 3, the addition of a citation with Rule 3 or 18 of the Vermont Rules of Criminal Procedure. Judge Zone, I believe, had suggested that addition to account for the requirements under that rule. And then moving down, subdivision 4, this essentially clarifies what happens at that initial appearance. So the way that this is structured is that someone who is alleged to have violated a condition of release, they can be arrested or cited to appear the next business day after the arrest before the judge. And so subdivision 4 addresses what happens at that initial appearance. So the defendant alleged to have violated condition shall appear not later than the next business day following the arrest or citation. At this appearance, the judicial officer may review and modify the defendant's conditions of release pursuant to section 7554 of this title. The prosecutor may also request that the judicial officer schedule a summary hearing in accordance with subsection B of this section, or elect to commence a prosecution pursuant to section 7559 of this title. So essentially brings everybody to court, and then they can figure out what they want to do. The judge has the authority at the outset to change conditions if need be, or the prosecutor has the possibility to continue with a hearing under this section or to pursue a prosecution under 7559. You'll see later on that those are exclusive remedies, so they have to choose one or the other. They cannot enforce it through both.
And so they still have to use the least restrictive, right?
For,
Violations.
well, if the judicial officer reviews and modifies the conditions by 7554, it would still be based off of that least restrictive requirement. So yes, in that circumstance, it would still have that.
Mr. Chair.
Yes.
I'm just wondering about the next business day, no later than the next business day. Is that standard language? That seems very rigid and immediate. And can it really happen that quickly?
I mean, we do have, this is for lack of a better term, a flash cite, and there are flash citations, I believe, for
Yes.
risk protection orders, if I'm not mistaken.
Yeah, and we often, if someone has a VCR related to a victim, we often request that there's a flash site, for example, contact with a victim or outside someone's house. So we, depending on the circumstance, we sometimes request flash sites.
But wouldn't we be saying, if this is a broader pool, it seems to me, anybody who's violated a condition of release, any condition of release, shall, not later than the next day, is that gonna, seems like that would increase the number of immediate hearings we would have substantially.
It may, I don't believe that, and I could be mistaken, I don't believe there's been testimony about that particular worry occurring, but it's possible. The other possibility is that while it would bring people into court, it may expedite resolution, because every time someone has the opportunity to get together, they may strike a plea bargain.
Yeah, I'm, and not disputing that. I'm just wondering, it doesn't seem to give anybody any flexibility. It has to be the next business day.
Right, that's true.
And then if for some reason it's not, what happens? Like,
well, it would have to be. They would have to move, you know, if there were scheduling conflicts, this would have to take priority.
okay.
So I actually have a note in my old draft of the bill asking if the courts can even handle this. And I'm wondering, if we limited it to, at least for the shall, to violations that are new crimes, because a violation might be, oh, I missed my counseling appointment. And maybe in that instance, I don't need to be back in court in 24 hours, but if I shoplifted again, I wonder if that's a way of meeting your, because I hear your concern, this could be have a real impact on the backlogs.
When you say if Judge Zone is available either remotely or in person.
This isn't directly related to this portion, but something that Judge Zone has testified to and has spoken to me about is that, you know, I don't think that he sees the need, and I don't mean to, I hope I don't mischaracterize his testimony, for this new mechanism necessarily. I think he says that you could explore revamping 7559, the contempt mechanism, or pursuing this one, or a complete streamline of 7554, or maybe a combination of some of
I don't
those.
think we have time to rewrite 75.
2 days to cross.
I would tend to agree.
So that it's either this or addressing it with with either of the suggestions, senators.
So, yeah, it could,
Because I don't think, I don't see it,
I was just gonna say, for this,
well, I just asked Ben to see if he can get a hold of Judge Zonay to give us a comment the next 45 minutes.
as to the shall or may, Mr. Pro Tem, I would say that you could, if you put in the may there, it would make our ask, let's say a state's attorney got a call about the counseling thing, like you mentioned, and be like, well, we're not gonna have them come in for that, right? But if has to do with the victim or has to do with, hey, you're driving again and this is your 4th DUI, then we need to get you back into court. So saying an individual may be cited based on the facts and circumstances, something like that.
Let's tentatively put in May.
Well, I like that
And then if
piece.
we have time to hear, if we can talk to Judge Zonay and get his comment. I
And
think
facts and
that's probably-
circumstances is what we work with in the
Yeah, I
bail
think
realm.
it's probably a good alternative, but, go ahead, why don't we continue on then?
sure, so in subsection B, there was sort of just a reorganizing of things. A lot of the factors that were in B are now present in D, and B really just explains that, upon request, judicial officer may schedule a summary hearing to determine if the defendant violated conditions. State has the burden of proving those violations by a preponderance of the evidence, so more likely than not. There's the admissibility standard, which essentially on par with the other bail statutes, with the exception of providing the judicial officer discretion to bring in live testimony if the officer feels it's necessary. And then the officer shall issue the appropriate order pursuant to subsection C. Subsection C is the disposition of violations. So in determining that a condition of release is violated, judicial officer considers any of the following. These were the things that were moved from B to D. Whether the defendant violated a condition of release that does not otherwise constitute an offense under federal or state law, whether the defendant violated a condition of release that also constitutes an offense, the nature of the underlying offense for which a defendant is charged, the defendant's prior convictions, history of violence, medical, mental health needs, history of supervision, risk of flight, and any risk that the defendant poses to the public. So the court considers those factors, and then upon a finding that the person violated a condition of release, the judicial officer shall, and this is a new addition, impose the least restrictive condition or combination of conditions to reasonably ensure the defendant's court appearances, to mitigate the defendant's risk of flight from prosecution, or to reasonably protect the public. Such conditions include imposing any condition or combination under 7554, or placing the defendant under the supervision of pretrial supervision program under 7554G. So those are the two options that someone has, the court has to address a violation of conditions of release. It also adds a subdivision 3 that notwithstanding section 7559 of this title, if the defendant violated condition of release that also constitutes an offense under federal or state law, a prosecutor may pursue bail revocation pursuant to section 7575 of this title. So that's another avenue that they could pursue, but it would have to be a different proceeding. And then D is the exclusive remedy, just changing some of the terminology, that a proceeding pursuant to this section or a prosecution pursuant to 7559 shall be the prosecutor's exclusive remedy to modify conditions of release as a result of an alleged violation. Otherwise, the provision remains the same as the last version. Any conditions or any questions on enforcing violations of conditions under this new statute?
Okay, that's right along.
And then section 5 is the electronic monitoring program, which remains unchanged from the last version, unless anybody has any questions about it.
Can we go to page 16, line 15?
Mm-hmm.
This is where, so this is where you determine whether or not the person's appropriate for electronic monitoring.
Correct.
And we just got handed department's policies. Well, Andy Polito was the 2015 policies. They haven't been updated since 2015. So, how does that fit with what's in? Does that comply? Or would you need to update?
I need to review the policy. But it does, I see it does mention GPS, so we can confirm that this was the satellite.
The only thing I want to flag here is the sort of open question about private for-profit entities. So we don't necessarily need to make a change, but I know that that's still a bit of an open question.
Our staff did note, sorry, I'll share that they're not aware of any nonprofit operator of electronic monitoring.
So the only choice then would be something like Wyndham County Sheriff's or another state
For
that was
electronic.
willing to monitor our people for a fee.
Well, I think the difficulty there, Chair, is the technology. You know, we use the monitoring itself, the companies that operate a pretty specialized space.
So there's are there two different vendors here? One, the company that does the monitoring, and two, the company that provides the monitor, the ankle bracelets or whatever you use.
I've asked for a copy of our contract agreement, so I can provide that with you.
Yeah, I think I may not understand. I don't think there's a problem from my perspective if the company that provides the technology is a for-profit. That's similar to having an X-ray machine.
Right.
It's the operator of the actual monitoring being for-profit
Yes.
that I think is a concern.
We do operate. I mean, our staff are the ones who are on call reviewing the data.
So if a private group like Wyndham County Sheriff or somebody else were to do, they wouldn't be providing the equipment.
Right.
We're not looking at the equipment.
Okay.
We're looking at who operates the monitoring, who does the actual monitoring. Am I correct?
Yes.
Okay.
Yeah, I mean, bigger issues with for-profit companies in those spaces, but that's not for this bill. My concern with this bill is who's doing the monitoring. And that should not be a for-profit entity.
Is that clear in the resolution?
Well, I was gonna say, I could clarify that it may support the operation of the program's monitoring or something to that
Mhm.
effect.
Yeah, because the equipment would obviously be
Yeah.
something that's for profit.
So who's gonna do the monitoring then?
Well,
Sheriff's
right
office.
now, currently.
You don't
the
think they're making a
department
profit out of that?
But they're not a for-profit entity.
does. Well,
They're an entity of the state.
that's a
good question.
Yeah.
I agree, but that's a different
If you
issue.
remember, Proposition 1 has not passed, so they're still for profit, but non-profit.
Not under, but not a corporation under the legal definition.
They're a public entity.
Yes, that's
So-
kind of my point.
Anyway, if it was the Wyndham County Sheriff's, or the state of Massachusetts, or the state of Wyoming. Yeah, I can see small states getting together and saying, let's have one monitoring system. You know, rather than spending money on,
Especially if people are going, over the border to different states, if you have someone from Vermont regularly going to New Hampshire, or vice versa. Yeah, so.
yeah, I can see the three northern New England states getting together and doing it. It's possible.
Yeah, but you are correct. My concern in this bill is the monitoring. You have to buy the equipment from who makes the equipment.
Right.
Okay.
So is there any still kind of to be determined on the nonprofit language here, or should that
I
be
think
inserted?
we're kind of clear on, it would be, the monitoring would need to be done by the state or nonprofit.
Okay.
agency. The actual monitoring, to make clear, it's the actual monitoring and not the equipment.
Okay. Okay, so I believe that these are the only changes to, well, there weren't any changes to that portion. Section 6, this is the establishment on page, 3/4 of the way down on page page 17.
Before we move on to section 6, I had some notes from our testimony. Maybe it was yesterday, maybe it was before, I can't even. And those were around setting some restrictions around not passing costs on to people being monitored. Again, my same flag around the defendant not being responsible for technological failures, and making sure that time served in an electronic monitoring or home detention program count towards any future sentencing.
Thank you.
I think those were my only notes from yesterday, or whenever it happened, but I know we didn't make any changes, and that's why I want to bring up that I'd love to talk about potentially making those changes before we move on from this section.
I think those are policy.
Yes,
considerations.
that's why I'm putting them out to the committee.
I don't think this is the report, this is over, this is new. I don't think it's the report. This is, no, this is the one that. Is it more? Yeah, it's too new to be. Yeah, it's way back. It had been filed in probably 2019, 2020 somewhere. Okay.
Chair.
Yes.
Very well. I just wanted to flag, here I may differ a bit from my colleague to my left here from the State's Attorney's Office, but on page 16, line 9, section 2, about the 24 hours a day, 7 days a week immediate response. So just to rehash a little bit about what we did last and what Ben was saying earlier about the active versus passive supervision. I think it's a bit of a misnomer, because even if folks do cut off their electronic monitoring device and can run, there's still going to be a delayed response in that. What the department found was that it was hundreds of thousands of dollars to provide active supervision for just a dozen folks, around the clock, having people kind of ready to go at the computer, when we found that we could achieve nearly, essentially the same response with passive monitoring.
Are you suggesting striking and immediate response?
I think that would make the most sense, to move to a passive monitoring model, or we may see a significant cost burden to taxpayers to implement a system like this. And I understand not all state government entities might feel the same way about that, but as the Department of Government tasked with administering the program, I could foresee
have a problem with issue. At least for this initial review, to strike that piece, but I think that.
Yeah, I just want to stay on the record that we do think that, given the potential nature of those who are supervised, the victims involved, et cetera, that I have the luxury of not having to worry about the cost, from where I sit, but I understand empathetic to that. We think where appropriate, like our federal partners, the ability to engage with someone 7 days a week is a luxury, but obviously one that may result in better compliance with the opportunity to not be in a facility.
Senator Rush.
Thank you. I hear your point with this, and I think my question would be, if immediate response is removed and it's passive monitoring, then when would the response happen?
So what would happen is we, get an alert, and our field staff would cover that during, normal business hours.
Okay. But the idea here is, well, the electronic monitoring could be passive, but the home detention can't be passive.
And as it currently stands, we've been able to facilitate home detention through passive electronic monitoring with little to no issue.
Currently, home detention can be both active and passive.
Right, but I'm saying that to be effective, home detention is the true alternative to incarceration. It can't be passive, in my mind, because if it's passive, we'll get you're endangering victims and others. I think there would be don't think it solves the problem.
The folks who are currently on home detention do have some pretty serious crimes. Granted, it's a small number of folks who are awaiting trial, but we haven't seen any issues with the passive monitoring.
Well, I've been assuming all along, and our joint fiscal report would assume that there was active monitoring, not passive, of the home detention population. If Judge Zoney's in the Zoom, maybe we can go ahead with your question.
Yeah, my question is around the fiscal note and whether or not that is going to compare the cost of incarcerating someone versus the cost of active monitoring. Because I imagine that there's some cost offset there potentially as well, because my understanding is it's like $90,000 a year to incarcerate someone.
I don't know, that would be a question for Scott Moore, he's the one working on it at JFO.
Okay.
Well, you can do the math pretty quickly. It's 94,000 in-state, 36,000 out-of-state. So if you don't detain 10 people, you saved
It's a fair amount of money.
a fair amount. If you don't put them in jail and you put them in whatever the monitoring cost would actually save money.
Well, and that's what I'm wanting to understand kind of explicitly, and I guess
So-
we'll hear from Judge Jonah and come back to this section.
Judge Jonah, that name. Judge Zone has volunteered to join us via Zoom. And we appreciate that. We had a couple of questions. I'll let Senator Hashim start off with this question.
Which question? Which question is that?
Oh, well.
Oh, the
Senator
immediate
Baruch,
response.
Yeah.
That,
The immediate response.
I think that may have, I think we might be mixing it. I think, my question was more so for DOC and,
Oh,
you know, what happens when passive monitoring.
so
Yeah.
the question came up
In a different
back in
section.
a different section, Judge, that had to do with flash citing people for violations, and it was a shall. And Ben, can you point us to the right page?
Sure, so this would be in, the,
Page 13,
yes, thank you.
line 9.
Thank you.
Yes.
Page 13.
I made a note.
Yes, and this is in the violations of conditions of release proposed enforcement mechanism, subdivision 4. That the defendant alleged to have violated a condition of release shall appear before the judicial officer not later than the next business day. I believe the question was what that would do basically for the court backlog, and if it would create more problems, if I captured it correctly.
Or if
So,
like add to the backlogs.
Right.
And should it be a mayor shall? That's really the question.
so Tom Zone, Chief Superior Judge, good morning. Yes, it would be, anytime we have something that has to come in immediately, it's a zero-sum game. We only have so many hours per day, and it will take away from the opportunity to address other matters. And when we have cases of, right now, this type of provision is in for domestic assault. And so there are times when it is important to get someone in right away. If it was a shall, it's going to bring in a lot of cases, I suspect, that the state's attorneys and the police may agree don't need to come in. For instance, if you have to bring in someone who might have missed a curfew by 10 minutes or done something that the state's attorneys would say, well, we don't need to bring them in right away. We already have conditions. We're not going to be asking for any additional conditions. Under the language that is on page 13, it would require them to come in anyway and disrupt the normal flow. So if it was a permissive may, that still gets the same point across, that there are circumstances when it is a flash site. I think right now, generally it's not flash cited for the next day. Usually they're put off in time. And if a message is sent out that there may be circumstances where you need to bring someone in sooner, then certainly that can be done.
So a may is acceptable to the committee?
Yeah, the only question I have about that, so Attorney Leaders Dumont suggested, based on the facts and circumstances of the case. Judge Stoney, do you feel like that should be added into this paragraph as well, or is that does that sort of go without saying?
I think that goes without saying. If you're giving the discretion to the state's attorney and law enforcement, it would be necessarily exercised on the facts and circumstances. I would hope that they don't just have a blanket saying we're going to do it every time, no matter what.
Okay. Thank you.
Okay. And there were some other questions. Senator?
Thank you. This might be a question more so for Tim, but I'm curious about about implementation in the field. If, let's say, an officer encounters somebody and, you know, they've violated their conditions, is that officer calling the state's attorney to say, you want me to flash cite this person, or do you want me to cite them several weeks down the road? How would that look?
Yes, I would say that you're correct. It would be a conversation, especially allowing for the permissive aspect of this. I think it gives us more time to figure it out. You can usually tell by the nature of what has allegedly occurred, the timeliness. And so, yeah, flashlight opportunity is good, but not demanding it, I think is helpful.
So would the discretion be with your office, or rather state's attorney's offices, or the police officer, or both? How would?
For a flash site, they call us.
Yeah. On another subject, Judge, the committee, the intent of the committee, I believe, at least the majority of the committee, is that this bill, in terms of home detention, that be seen as the most restrictive of the non-jailable alternatives. So we want to make sure that it's clear that our intent is that people who are in home detention would otherwise be incarcerated or be held on large amounts of bail. The home detention program from the Windham County Sheriff's Office focus mainly, I think, on domestic violence, serious domestic violence cases. So they clearly would have been alternatively incarcerated. Is that clear in here through the least restrictive in your mind? I hope that question came out.
I understand the question. I was just looking for the language.
Yeah, and Judge Zoney, to help orient you, on page 4 and 5, the electronic monitoring and home detention has been added to the list of conditions that can be imposed under 7554. And so I think Senator Sears' question is tied to that.
So I would say that the absence of any language indicating that type of preference would make it on par with the other conditions that are within subsection 1. So I don't think that would be clear from the language.
Okay. So we need to make it clearer that this is the most, we always use the term that the person has to be in the least restrictive, but this would be the most restrictive non-incarcerated alternative. I don't know if that may, how do we do, I don't know how, Ben's gonna be able to write it.
Yeah, I'll play a little bit, but I mean,
You think it has to be spelled out?
If that's your intent, if you want the court to consider that you only get to this at a certain point, I think it would be helpful to be spelled out. Otherwise, if someone is coming into it, but it's already, when you look at 7554B, that's where you're going to have the mechanism to utilize the home detention program. And so I don't know if you need to add it here, because if the judge is in 7554B, he or she is going to already be utilizing that statute for determining whether someone should go in. But you could certainly put in language that is here. It's done it up above, where it talks about qualifications. For instance, under subsection A, it does say what type of offenses do not qualify or do qualify for someone to be in that section. And so it would seem that you can add qualifications here, and that would get you to the same place.
Yeah, I think we could put it in 7554, attach some language to that condition. You could probably also put in an intent provision in the home detention statute as well. Kind of outlining that the General Assembly's intent that this is considered the most restrictive of non-incarcerative options. When considering imposing it as part of bail. So you could do both.
Yeah, I think that would be.
So to add the language to both the home detention statute and the bail statute?
Yeah.
Okay.
Yeah, I think that addresses the concern that the legislative intent is clear. Are there other questions for Judge Zone?
I do recall, I think my colleague Tim Dumont did ask about, I think it was on page 12. On the failure to comply with the conditions of home detention, so that this has been changed, that the Department of Corrections reports a defendant's unauthorized absence or failure to comply to the court for review of conditions under 7554, a proceeding under 7554E, a prosecution under 7559, or bail revocation hearing pursuant to section 7575. I believe Tim asked how that would really play out within the courts, a report from a DOC employee to the court itself. I do think that an addition of "and the parties" so that everybody has a copy of the report is necessary, but did I capture your question correctly?
Yeah. And so as I look at this, it does not have clarity as to how the process works. Is it in the nature of the state's attorney needs to generate it? The court is probation a party. In a violation of probation, the probation officer can file the violation directly. This is not something that probation would be a party to generally at this phase of the case pre-trial. And so it's really creating a separate mechanism that probation would have to have the ability to make filings and the court would have to respond to them. Alternatively, what you could have here is that they report it to the state's attorney who shall file a request with the court for the review. That could get us to the same place. But if the intent is that the court, the way I'm hearing it and the way it looks is that this is a shall, that if they file it, we have to have a review hearing. And so we just have to make sure it's clear that basically they have party status when they're involved. Otherwise, they wouldn't have any ability to make that filing.
Yeah, you could have it go that the state's attorney shall be notified, and then the state's attorney may elect to file, etc. That way it provides mandatory notification from the to the state, who is the party, without the court necessarily getting involved unless the state's attorney chooses to file something, which would be how we do BCRs anyway.
Very helpful.
Is that the direction that the committee would like to go through the state's attorney? Okay.
I think the majority include. So, are there any other things from Judge Zone? Judge, I don't think so, but thank you so much for appearing on short notice.
Oh, my pleasure. My pleasure. Glad I was able to do it. Have a good day, everyone.
You're welcome. If you want to stick around on Zoom, you're welcome. If you've got to be somewhere else,
I'm actually heading to a conference, and so I wasn't. I even when I got the message, I even put a jacket and tie on quickly, so I could do it.
Oh, well, you don't have to do that for us.
Well, thank you. So have a good day. And
Next week, we're going to try to arrange a budget day. I'd suggest you.
I'll be there. But if there are any additional questions, Ben can, as he did now, just email me and I'll get right on.
Okay.
Thank you.
Thank you.
All right, have a good day. Bye-bye.
You too, thank you. So I think, is there other stuff here? Where were we?
I think we're on page 17,
Yep.
and we're about to embark on the pretrial supervision program,
Mhm.
I believe.
Yeah, I think,
Yeah.
Right?
I mean, I was hoping to, I think you were looking at a report when I had brought up on the
Oh, yes.
electronic monitoring, the points around not passing costs on to the detainees, not holding the defendant responsible for technological failure, and time served in those programs counting towards any later sentence. Just adding those pieces into here.
I think they do currently, don't they?
Count for time served.
The home detention counts as,
Yeah, well, home detention does have a provision for credit for time served.
And does DOC charge presently for the monitoring system in any way?
Charge the individuals on.
Yeah.
But we could, no, I think there's this, supervision fee, but that would be for adjudicated votes, but.
we've always had a
that's just-
supervision
That's just a
fee.
monthly, that's not- yeah.
But I believe Senator Viofsky is talking about the electronic monitoring program, if I'm not
Yeah,
mistaken.
no.
Yeah.
I don't think so, but we can double check.
Okay. Okay.
But there, for the electronic monitoring, there is no provision about credit for time served.
Well, I think they're two separate programs.
Yeah, I was gonna say that there is sort of I think a fundamental
You're-
distinction between the two.
You're not, you may be restricted that you can't be within a certain distance of somebody or something. But you can also have that same restriction while you're on, without, on the regular requirements of, you're released on recognizance, but you shall not be within 100 feet of X.
Correct.
The home detention, you are restricted
Right.
in what you can do, and so I think there's a more legitimate reason to provide credit.
And at least in its current form, think about it, it's people that would be in prison otherwise that would potentially be in a position to earn credit for time served, so.
So I don't have a problem in that area.
Right.
That makes sense. I will wait to hear from DOC, again, around passing on the cost. And part of the reason, again, that I want to codify some of this around cost and technological failings is if we're expanding the program, things may shift and change. And I just want it to be really clear that the cost cannot be passed on to the detainees and the defendant is not responsible for legitimate
Well,
tech
Ben, if
failings.
you can just arrange an amendment that does that, and then we can discuss the amendment when.
So add a provision that basically
Yeah, just,
technological
well, maybe
failures.
a separate page, and then the committee can discuss it the next time we take this up. which
Perfect.
Hopefully it'll be tomorrow, because we gotta get it out of here.
And we're happy to provide a content matter expert from our team that can speak a little more
Okay.
detail about the electronic monitoring program.
Yeah, I just
I
want to
believe there was no charge in the Wyndham County. I'm just looking at the report.
And I got confirmation that we do cover all costs for monitoring.
Yeah, I recognize that when you expand something, things can change and want to be clear about what changes are allowable.
To answer your earlier question about, in the Wyndham County Electronic Monitoring Program, it's demonstrating initial cost avoidance. The cost analysis is very preliminary. However, the initial proposal estimated a savings of $2,210 per defendant, avoiding the cost of detention. For the 10 defendants that have been successful in the program, the initial cost review is well beyond the amount that was anticipated. In other words, the savings are much greater than what was anticipated. Senator Rose.
Quick question with, so I fully agree that the defendant shouldn't be paying the fines for this, or the costs for this. But are we still going to be, but it's, still going to cost something. So I guess the question is, where will that money come from? And is there still going to be a contemplation as to how we're supporting sheriff's office, whether it's Wyndham or elsewhere in the state, as to, what funds they get to run this program?
They would contract with the state to provide the service. What they did before was contract with the state to provide the service. the funding came from DOC, which is generally general fund. But there was a cost avoidance. What I just read was 2,210. I think it was much higher than that. And if you're looking at, if detention is reduced by 10 people in the program, and you saved, say, 40,000 per person, you're looking at 400,000 savings. And then you have the cost that you have to sell. You'd have actual savings in the budget. Because the one good thing about the out-of-state program is you can really follow the money. So if you have 100 people out of state and you drop it to 90, you can follow that money that you saved of those 10 people. In state, it's hard to do because you're still operating the facility. If you reduce 10 people, it's still got the same operating cost.
Yeah, the cost estimates are in some ways, I think we shared last year, a bit of a crude calculation, because you can take the entire out-of-state contract cost, but that does include administrative overhead from the department that's not really captured in the contract.
Yeah. But it's safe to say it's about $40,000 cheaper.
Yeah, I mean, it's a longer conversation, but.
Understood, but it's
Yes.
about 40,000. When it all comes down to the money, it's about 40,000 cheaper to haul somebody out of state than in state.
Yeah, I think the current cost is about $36,000 per individual compared to about 98,000
So-
in state.
At any rate, so by not having them detained, because every detainee is in state, they're not allowed out of state, am I correct?
Only sentenced individuals are out of state.
Okay, but generally, if you're on detention, you have to be in state too. So, yeah, anyway, I don't know what the thing, so we're gonna go to we got about 5 minutes, Ben, to go over the pretrial supervision.
All right, I'll just go over the changes from the last
The
version.
change we made here is the important change is that you can be in the home detention electronic monitoring before you have a violation. You can only get into the pretrial supervision if you have a violation, am I correct?
Well, that's one way to get into it. Because one of the changes that I made, if you look at page 18 in subsection C on line 5, because before it was, you had violated conditions of release pursuant to the 2 applicable statutes and who pose a risk. This was changed to or who pose a risk of non-appearance at court proceedings, pose a risk of flight from prosecution, or pose a risk to public safety. So that you can have a violation and be, basically submitted for eligibility into the program, or if it's deemed somehow that you are a risk of non-appearance, a risk of flight, or a risk to public safety, you can as well, but that can be restricted more fully.
So this sort of gets at my concern that we're waiting for people who we expect to struggle to actually mess up.
Well, but the other way to look at it is, do we want people supervised who don't need supervision?
I don't think we do, but what I was concerned about last time is that there are people that we might look at their previous record and say, this person is pretty likely to struggle to meet these conditions. Let's provide them the supports and services before they violate so that or we might look at this person and say, this person has some significant.
I'm gonna take my Rolodex back, because now I'm on the liberal side, and you're being very conservative. Because I'm on the liberal side saying, no, they shouldn't be supervised until they screw up.
Well, so I don't look at this just as supervision. I look at it as services as well, making sure that someone who doesn't have housing is getting the support to access housing through this program, or someone who, needs help finding a job so that they're not needed. Like, I don't just look at this as supervision. I look at this as pretrial supervision and services. And so I guess, and that's how I read the intent of this language as well, that it is to assist eligible people through the use of evidence-based strategies. And so for me, it's about preventing them picking up additional charges, not simply supervising them. So, and maybe that's not really what we're setting up, in which case.
Would that get you to vote for the bill?
So just to further clarify, so this is not,
Maybe.
pretrial supervision is not what I'm gonna say, one of the menu items under the bail statute, like home detention and GPS is, right? The way it's structured is that you don't necessarily have to have a violation to be eligible or to be, considered eligible to be in the program. If you are put on conditions and somehow there's a violation or whatever, or maybe there's just something that occurs that comes to the attention of the prosecutor, that's another avenue in. So it doesn't necessarily have to be a violation to get in, but it's not something that's going to be issued at the outset. A way to think about it, given different eligibility requirements, is that it's kind of structured like home detention in the sense that, like, if you meet certain qualifications, this can be an avenue for you, but it's not something that's given to you at the outset.
I guess then I'm not reading the language here correctly, because when I read on page 18, line 4, when it says the supervision program shall supervise people who violate conditions of release or who pose a risk, that could be at the outset. If there is an evaluation done right at the beginning that says this person poses a risk.
But it's not one of the initial conditions that can be offered under 7554.
And then
Could it be added?
It could.
Well, I think this is a fundamental issue for
Yeah, this is a
us
policy.
to deal with, policy choice. Should people who be able to have pretrial supervision enter into the program who haven't exhibited problems? I just don't want it overused.
No, me neither.
I'm sorry, I called you senator. You're not there yet, but I didn't know if you're running or not.
Thank you, Chair. So just to, I think to your point, Sarah Prohosky, it's a really good question about, our field staff are wonderful and they are very good at using community resources and setting people up for success. At the same time, I do agree with Senator Sears that in some ways it is a punitive mechanism. It is an arm of the criminal justice system, and that if we can avoid having folks on additional supervision for, if we want to avoid having people on supervision for long periods of time, because we know the longer they're on supervision, the more likely they are to have a violation. So in general, I think we want to be careful about not putting the carceral system in charge of coordinating social services. So just want to make that clear.
I agree with your point that we don't want to put the carceral system in charge of providing social services, but the reality of it is in this nation, they are the biggest provider of social services. And so I don't want people who don't belong in this program to go in this program. I want to prevent people from getting into more trouble. And if this is the arm we have to provide those services, then I want to provide the services.
And Senator Bielski, just to highlight the distinction in the last version is that before that and it had to have been, you would have had to have a violation and also pose those risks. This one makes a distinction, but if this still doesn't get at what you want, and granted it's the policy consideration, if I recall, you were concerned sort of with like mental health needs as a result. I mean, that could fall under a risk to public safety, or we could even be more explicit in listing those concerns.
Senator Sheen.
Thank you. I guess a quick question tied to this. Page 18, line 11 and 12, the pretrial services needed by the supervisee. Are you able to provide a quick list of what those are? Or could DOC do that?
I would defer to DOC.
18, line 11 and 12.
So that the department shall assign a pretrial supervisor to monitor supervisees in a designated region of Vermont and help coordinate any pretrial services needed by the supervisee. So that was an attempt to, if they need mental health services, might be but I'm not aware of what DOC actually can offer.
Right, and particularly given this is new policy space for us, that we have, we've operated home detention, which is what, the 5 or 6 people as of this morning, but 5 people, but, this could, I think we would have to take a look at this language and try to understand like how this might impact our operations, because we've never operated in this space before.
Yeah, that's one thing I'm wondering about. And the other piece, I mean, if this is something that's expanded, how would that affect what the 6 employees who were being appropriated for this? I mean, how would that affect their workload and attention to detail on the folks who have violated conditions of release and the supervision that they'd be providing them?
Well, I think the department certainly has concerns around just 6 individuals. I know at one point, I think Crime Research Group estimated about 8,000 people or so who are currently awaiting trial. We have about 4,000 people on supervision, and that's overseen by about 200 or so field folks. So we just want to be cognizant of not setting up individuals for success if we only have 6 positions available to monitor up to 8,000 people, depending on how we're narrowing who would be eligible. Thank you.
Are you done?
Yeah.
I hate to say it because we're at an advanced stage of looking at this, but I do have questions about the money involved, the positions involved for a new program, because we've talked many times about the excessive needs of the judiciary at this moment, and we're trying to plug them at all levels. So getting rid of the backlog, but then making the Defender General commensurately advanced, and legal aid, and I think we're gonna wind up in the tens of millions of dollars for that stuff. And then this is, as I read it, it's not 6 employees, it's 7. And I hear DOC saying it would probably need to be grown from there. So I'll just be honest, I have questions about whether this is the year to start a program like this. Although it does.
I guess I was preparing for appropriations to discuss that
Yeah.
issue. I would say, number one, if the home detention program works, it's gonna save money. And that money could be reinvested into pretrial supervision. Number two, if we're really going to try to solve the problem, violations of conditions of release, we have to find better ways to help people avoid criminal activity. And when we got here this year, I think one of the priorities from the public anyway, maybe not from the leadership, was to deal with this constant so-called revolving door or catch and release policy. And I think what we've come to is a reasonable alternative to the idea of lock everybody up. And just increase that problem that I think you pointed out in the first initial conversations with Jay Johnson from the administration. And I think, the way this bill is morphed into more of a bill that will hold people accountable. And one way to hold people accountable is to have pretrial supervision. It may result in more people being detained in the end for violation, but hopefully it would be quicker and shorter detention than what we end up with now after 45 violations. Public's up in an uproar. I think we determined that it's a very small number, but that number generates so much publicity in the communities and so much angst amongst constituents. They see it as the norm, not the rarity. And so I think this program tries to address that. So that's my justification. And if need be, I would suggest that there are always ways to fund something. But we can battle that out in approach. It's a good point, Senator. I don't disagree at all, but I think we were tasked with coming up with ways to deal with this problem, and I think we've come to identified the problem and are trying to solve the problem.
Yeah, I'm just thinking
Yeah, I understand.
And I think the bill comes at it 4 or 5 different ways. The problem of violation of conditions of release. So I'm just flagging that as a concern.
Yeah, I don't think Senator Kitchen's gonna be thrilled with it.
Very quickly, Senator, sorry, just one more point to that is that I think, so they're currently written, and I think, I haven't seen this latest draft, but I think it still preserves the 6 pretrial supervisor.
Plus the administrator.
Plus 1 administrator.
Yep.
Right.
I think, we have 12 district
Right.
offices, so I could imagine there could be a geographic equity component if you're forced to, you have to meet with your pretrial supervisor, but you're in Morrisville, but the, closest office is, you'd have to go down to another office.
Well, but the goal here of limiting the people who would be in the pretrial supervision assumes that there are actually smaller numbers violating conditions of release that would need pretrial supervision than what the general public sees, because it's only, in my mind anyway, it's a small minority of all of those people who are released on conditions every day in our courts who actually violate the conditions and end up state's attorneys bringing them in to court. I'm sure many violate that you don't even bring to court.
Yeah, and if I can make one distinction, the distinction between persons and dockets. So one person in your county, for example, might have 50 dockets, which takes up a lot of time. But that distinction between one person taking up a lot of time as well is like that person might be a good candidate for supervision in a more elevated manner, more access to services, et cetera, as opposed to a first-time violator for a condition of release with 1 docket. I just wanted that distinction of one person might have many dockets.
My guy was 45.
That's right, after
45.
I think I referred to him as your friend at one point, and I'm sorry.
It might be helpful.
I don't think he's a friend. He may be an acquaintance.
I think it would just be helpful for the department if we were tasked with administering the program from a staffing perspective to get a better sense of how many individuals we would be supervising in the pretrial space, and then we could calibrate the staff needed to do that supervision.
We're guessing.
Well,
Senator, sorry,
it's okay. I know Senator Goffsky.
If you wanted to weigh in on this piece.
Yeah, well, I was just gonna say, I know that the department had initially asked for 12 and 2 support staff. But as far as the geographic equity piece that Isaac mentioned about meeting someone, if you look down, face-to-face meeting is not the only method of supervision. It's the telephone monitoring system the department has, telephonic meetings, in-person meetings, or any other forms of contact. So that may help bridge the gap of, going to somebody's place that was halfway across the state.
it's hard to guess how many people would be in the program. I don't think it's a huge number.
I think the commissioner would probably, just to speak for him in this setting, I think we would just like to have a sense of how many folks we're discussing as we're making the staffing decisions, just to make sure that we could
How would
effectively
you
operate.
find that out? Through the court records? I don't think we're gonna be able to get that between now and the time we vote the bill out.
And we can also go through how the court determines eligibility, and that may help inform these to a
We've
degree.
gotta take a break and go on to 58. I think we're pretty well finished.
Yeah, there are some changes that, in this portion that I can very quickly go through if you'd
Why
like.
don't you quickly go through the.
Okay, so for instance, you'll see on line 15 of page 18, shall is changed to may.
Yep.
So they have the discretion. 3 clarifies that it's the court that orders the conditions. So if the court determines that the defendant is appropriate for the program, the court shall order an issue placing the defendant in the program and setting the defendant's conditions. Supervisors notify the court that placed a defendant in the program of any violation of supervision requirements committed by the defendant based upon a sworn affidavit of the defendant's supervisor. The court may issue a warrant. I think given Judge Zone's most recent comments, I think it may be wise to change this, that it goes through the prosecutor again, rather than the court itself. So that would just be a humble suggestion on my part to the language. And then, again, there's sort of that flash site language, but that shall can be
I think
changed
we
to
determined it should be
may.
May.
Yeah.
Senator Ruth is correct.
And then, you'll see here, that rather than someone's eligibility, being based off of having a Vermont residence or a Vermont telephone number, basically they're eligible, if they have violated conditions of release or pose a risk of, to safety, risk of flight from prosecution or of non-appearance. And then you'll see in subdivision 3 on page 20, just sort of some clarifying language that, you know, the court shall consider any of the following factors in making the determination, and then compliance and review was changed. Initially, it was if someone was compliant for not more than 90 days, they may have a reduction of sentence, or if they were uncompliant, they may have an increase in supervision. This allows that the court, prosecutor, the defendant, or the pretrial supervisor, which I'm probably going to remove given Judge Zone's comments, a defendant's compliance with pretrial supervisions may be reviewed, and the court may issue an appropriate order, saying that if the defendant who complies for not less than 90 days, they may receive a reduction in supervision or may be removed altogether. A defendant who violates may receive an increase or other sanction permitted by law. So those are the new changes to that portion.
All right. Do you have a redraft for tomorrow
I can do it, yeah.
at 11 a.m.?
I'll be there.
So we can schedule this for 11 tomorrow.
Yep, I'll put it on.
Take top 4 off of the Fridays, because we're not gonna get there.
Okay. Okay. We don't get chance 285 the first item on Friday then?
No, we'll see where we get on 58,
Okay.
Phil, you got 2 minutes?
just to be announced.
Are we breaking now?
Okay, Ben, thank you.